Hi, this is Steve Aycock. I'm a registered patent attorney at Signet IP Law, a small firm that I established in Central Florida about 10 years ago. And I'm also a course creator for courses to help inventors protect their ideas. And today I want to show you about 4 ways to protect your ideas. The 4 ways I'm going to cover are patent, trademark, copyright, and trade secret. Let's get into the patent side. The utility patent covers the structure and functions of inventions. It has a 20-year term from the filing date. It does have maintenance fees, which are periodic fees that are paid to the Patent and Trademark Office to keep the patent in force. And there are 2 types of the utility patent, a provisional and non-provisional. The provisional patent application is a placeholder patent application. It establishes patent pending status for your invention for up to 1 year. It has a lower upfront cost because the application is not quite as formal as the non-provisional, and the government filing fee is lower. One downside to provisionals is it typically adds extra time to receive a patent because of that first year that it's pending, it doesn't get examined. The other kind of patent application on utility side is a non-provisional. And this is just your regular patent application. It gets examined and it can issue as a patent. It has a higher upfront cost because the application has to meet certain rules for the patent office, and it also has a higher government filing fee than a provisional application. However, the non-provisional filing is the fastest way to get to a patent, so it does have that benefit as well. And after the provisional application is pending for 1 year, at the end of that year it's typically converted to a non-provisional filing, and that is this regular patent application here. There's also something called a design patent. This patent type protects the ornamental appearance of an object. It has a 15-year term and it has no maintenance fees. Design patents can be very powerful for inventions that have ornamental features where what you're wanting to protect is the appearance of the object that consumers would recognize or customers would recognize and want that particular appearance. So design patents are something to consider, especially if your product is a physical consumer product. It's important to consider it for that. And design patents can also be used to protect the user interfaces of software or mobile apps. All right, the second way to protect your idea is through trademark. Trademarks are used to protect the branding, such as name, logo, or slogan, and they can be maintained indefinitely if renewed. So this is the type of thing where you see the capital TM next to a logo on a product. That means it's intended to be a trademark. And sometimes you see a R with a circle around it, like shown on the slide here, and that means the mark has been registered with the Patent and Trademark Office as a federally registered trademark. A third way to protect your ideas is through copyright. Copyright is used to protect creative works such as artwork, books, photographs, text, videos, etc. Once the copyright is registered for your idea, if it's in the creative works area, there's no renewal needed. And finally, the fourth way to protect ideas is through trade secret. And this is done by establishing a policy and procedure to keep the information secret. There's no government filing needed for trade secrets. They can last indefinitely if the trade secret policy and procedure is maintained. And a commonly cited example of a trade secret is the formula for Coca-Cola that's been a trade secret for over 100 years. All right, let's look at some examples, different types of ideas, and the way that these 4 types of protection can be used. For physical product ideas, we typically think of the patent first, like utility or design patent, and trademark for the branding on the physical product. For a software or mobile app idea, trade secret can be used to protect the software, especially if it has some particular algorithm you want to protect. Patent can be used in some cases to protect the software, either through a utility patent that protects the functionality of the software, or through a design patent that protects the user interface features of the software, for example, in a mobile app. Copyright is used to register the copyright of the source code itself for the software. And trademark can also be used to protect the app name or the software company brand name. For food or other process type ideas, trade secret is one you want to think about for sure to keep your recipes and processes secret. Patent is sometimes considered for food, but not that often. It's usually only considered on certain technical kinds of food or chemical type things that are done with food, that kind of thing, additives, flavorings, sweeteners, that type of thing. But it can be used for food. It can also be used if there's equipment involved in either making the food or dispensing the food or beverage item. Patents are often used in conjunction with the equipment that's used for the food. So if it's a combination of a recipe and something that mixes it, or something like that, you can look at patents to possibly protect the combination of your recipe and the equipment used for it. And then for artwork or other creative work ideas, copyright registration for sure, and trademarking if you want to for brand protection on that. So this gives you a kind of an overview of 4 ways to protect ideas and the different types of protection that are used for different types of ideas. I hope you enjoyed this overview, and if you have any questions, please see my contact information in the description. And if you enjoyed this and want to see some more videos about protecting ideas, please be sure to subscribe and like the video. Thanks so much. We'll talk to you next time.